When you last enter the United States, and I'm speaking directly to the F1 students who are tuning in on this, last time you enter the United States on an F1 visa, you might notice that on your entry stamp, you see a D/S. That D/S stands for duration of status, meaning that as an F1 student, you can maintain your F1 status after entering the United States so long as you continue to participate in your educational program. And that can include undergraduate studies, master's degree, doctoral, what have you. It even includes OPT, optional practical training, if you want to work a little bit after you conclude your studies. Well, that might no longer be the case. If DHS's proposed regulations come into effect, the next time you receive any sort of a period of admission for your F1 status, it will no longer be duration of status, but instead for a fixed period. It can be for as long as 4 years maximum, or it can be as short as the last day of your current degree program. Now, you might be wondering, well, then what happens to people who take longer than 4 years to finish their undergraduate program? What happens to the people who, after getting their undergrad degree, plans to pursue a master's or a PhD? That's where extensions of status will come in. F1 students used to enjoy the benefit of not having to apply for an extension of status, and now they're going to join the other non-immigrants who typically had to deal with this procedure. For students who take longer than 4 years to finish their degrees, they better have a very good reason to support an application to extend their F1 status. Students who are planning to move on to OPT or master's degree program or PhD, any other kind of continuing study, will also now need to plan to eventually extend their status. To make things even more complicated, an extension of status application can potentially be abandoned if, while the application to extend status is pending, the student decides to leave the United States. In addition to applying for extension of status while inside the United States, a student might also opt instead to just leave the United States and then be readmitted after returning to the US under a new period of admission under F1. No matter what path the student chooses, this is definitely going to be more inconvenient, difficult compared to before. You know, if you're admitted under a duration of status, you don't really need to do anything other than just pursuing your course of study, and then you can indefinitely maintain your F1 status until you eventually transition out of F1 into, say, the H-1B or something else. With this new, let's say, regime of regulations, the students no longer have that luxury. They have to periodically either opt to extend their status while in the United States or leave the United States and then return. We're not even talking about the micro rules, such as, considerations of whether leaving the United States and returning to the United States is feasible because your visa is no longer valid. We're not talking about potential rules concerning abandonment of your extension of status application if, while it is pending, you leave the United States, go home and visit your family. My purpose today is really not to discuss the details of those rules because those rules might change after the notice and comment period, but instead, my goal is really just to appraise you guys of what might happen in the near future. With that said, I do want to cover some of the things that I found while reviewing the proposed regulations. The two most important topics are probably the people who are already in the United States under F1 status, what happens to their duration of status admission, and next, if we do need to extend or apply to extend your F1 status, what are the procedures and what sort of standards are they looking for? So, what happens to the students already admitted under duration of status? The general idea is an immediate conversion from duration of status to a fixed period. The ending date for the fixed period is whatever ending date the student currently has for their current educational program. So, if your undergrad degree is set to end next year in May, then your current duration of status admission will be converted to a fixed admission period that ends in May next year. Simple enough. What about the people who plan to apply for OPT? Well, if you continue to stay in the United States even 60 days after the proposed regulations come in effect, and within 6 months of the proposed regulation coming into effect, you apply for OPT, then you have the benefit of not needing to apply also for an extension of status. Those people who already have an OPT application pending, meaning the work permit application is already pending when the rules come into effect, don't have to do anything more. Their new period of admission is just going to be the end date of the work permit that they receive. And finally, if you're applying for any sort of a permitted F-1 work that is not post-completion OPT or a STEM OPT extension, then this pending I-765 is really not going to affect you. Your new period of admission is just going to be your current program end date. Let's move on to the application for extension of F-1 status. How is it done? What are the standards? Before even applying for an extension of status, your DSO will have to first make a recommendation to extend your status and endorse it on a new I-20, and this needs to happen before your current admission period expires. And then, before your current admission period expires, you have to submit an application form to extend your F-1 status. It is most likely going to be the I-539, that's what the proposed regulation states. But it could be some other forms because DHS is reserving its right to use any form that it wants. I think it's likely to be I-539. That tends to be the form that you submit when you want to extend any sort of status. Besides specific employment-based non-immigrant statuses, that would be the I-129. So I'm thinking I-539. Maybe they decide to add an F supplement to that form that students will need to start filling out. That's my best guess. Filing address, filing fee, whether this form can be filed online are all still up in the air. The proposed regulations didn't state anything about those details. There are 3 broad categories under which a student can apply to extend their F-1 status. The first is compelling academic reason. Second is medical illnesses or medical conditions. Third is circumstances beyond the student's control. I expect most of the extension application will fall under compelling academic reasons. Now, the proposed regulations didn't really state the specific kinds of situation that make up compelling academic reasons, but I can hazard a guess. If you are transitioning from an undergraduate program to a graduate program, that's probably a compelling academic reason. If your undergraduate program, for whatever reason, say if you're in engineering, for example, it really requires most people to continue their programs for at least 5 years. That's probably a compelling academic reason to gain an extension for your F-1 status. Students who have received academic probation, suspension, they have demonstrated an inability or unwillingness to complete their academic program, as demonstrated by, say, repeated failures in their course of studies, requesting multiple program extensions. Those students will likely not be very successful when applying for an extension of their F-1 status. If a student is requesting for an extension because they've suffered some debilitating illnesses and they have to temporarily suspend their studies, they have to supply evidence, doctor's notes basically, that show those illnesses. It bears noting that notes, medical documents from licensed psychologists and licensed clinical psychologists are also potentially acceptable to support an extension request. The final category, circumstances beyond the student's control, is the catch-all provision. In addition to what we've just discussed, this provision basically accepts and recognizes that there are a whole lot of compelling reasons that might prevent a student from reasonably attending school and completing their educational program. So things like natural disasters, institutional closures, a national health crisis are all some of the examples listed in the proposed regulations. There can be other situations that can support an extension of F-1 status, but this is going to be a heavily case-by-case analysis. In addition to everything I've just discussed, the student must now also supply proof that they can fund themselves through the rest of their educational program. After submitting the documents and the forms, there is potential for a student to be called in to do biometrics, basically getting the fingerprints done. And if at all warranted, they might be called in for an interview. This is probably not going to happen to everybody, but it looks like DHS is preserving its authority to be able to do things like that so that they can look more deeply into the student's background. And just as a reminder, applying for an extension of status while inside the United States is not the only way to extend your F1 period of admission. You can also alternatively leave the United States and then be readmitted under the F1 again. Of course, taking that alternative means that you're dealing with a different agency, Customs and Border Patrol, instead of U.S. Citizenship and Immigration Services. They have a whole different procedures, whole different adjudicatory standards. That in itself carries some risks. So there's really no easy decision here. But that is pretty much all we know so far about the proposed process to extend your F1 period of admission. Not a lot of details, admittedly, but it does tell me a whole lot about what DHS plans to do with F1 students. Fundamentally, I just think that they want to apply stronger pressure on F1 students. They want to apply a higher scrutiny. The reason supplied in the proposed regulation is to prevent fraud, and then they list a lot of examples of how some bad apples, some students abuse the F1 program to indefinitely stay in the United States under the guise of students, but really they just want to live here and work here under the F1. We can be skeptical about whatever policy reason DHS puts forth to support these new regulations. My interest is to really find out how those regulations work and how I can help you guys navigate these new road bumps. And finally, I want to just add a note on what these proposed regulations call changes in education objectives. Remember just a moment ago I said that DHS is interested in identifying people who fraudulently pose as students but actually just want to live and work in the United States. Well, these there are a couple of rules that are proposed here, and I'm just kind of loosely gathering them into this final section here, that seek to discourage these people who want to fraudulently use the F1. The regulations are proposing that first-year students cannot change their degree major, and they cannot transfer from one school to another during their first year. Similarly, graduate students, and I'm assuming master's and PhD students here, perhaps also law school students and med school students, they cannot change their objective or transfer to another school either. Those who have completed an education level cannot then try to complete the same education level under a different course of study. So let's say that you've completed your bachelor's degree in English literature. You cannot then also apply for and then enter another program, another undergrad program for, let's say, physics. For those who are able to transfer programs from one school to another, for example, they must begin classes within 5 months of ending their previous program. Same rule applies for those who are about to complete their post-completion OPT and are about to transfer to a higher education level, for example. Side note, you cannot make that transfer if you are not currently doing a full course of study. I know this is a lot of rules to absorb, and given time, we'll be able to put together a video that can bring these rules to you in a much more organized way. There's just really no merit to do that right now because we are in the notice and comment period. DHS has proposed these regulations and have opened these regulations up for notice and comments, and I'm thinking a lot of lawyers like myself, a lot of schools, a lot of students are just pouring their feedback in to DHS, and we're going to see what comes out on the other end. Whatever happens, once the regulations are set in stone, we will put out another video that, in a more organized way, summarize what changes are made to the relevant regulations. Until then, I'd like you to just review this video for a little bit and think about what's possible in the future and prepare accordingly. If you have any need for any sort of immigration help that's either directly related to this or not, please just leave us a message, send me an email, and we're happy to talk.